We're on the record in case number 4:17 CR3038, United States of America versus Michael Wayne Parsons. Counsel, enter your appearance. Please stay seated while you do so, beginning with the government.
Good afternoon, Your Honor. Jan Sharp appearing on behalf of the United States.
Good afternoon, Your Honor. Don Shinzi appearing as counsel for Michael Parsons.
All right, and Mr. Parsons is also here and present. The purpose of this hearing today is to, first of all, it's a Rule 17.1 hearing. It's essentially for me to get up to speed on how this case has progressed so far. And I would like to get a trial setting on this thing if possible today. So, but I need to hear from the attorneys on that. I also see that on the record that there were 6 motions filed 2 days ago. Of those motions, 3 of them are really in the purview of the district judge assigned to this case, which would be Judge Gerard, but I can still nonetheless get some information from the attorneys on what we plan to do with those. And the others, I'm clearly going to ask you what we're doing. So let's first of all get a lay of the land of, and start, I'm going to start with Mr. Shensi on this, a lay of the land of where we are in the discovery process and the ability to review the discovery thus far. Mr. Shensi.
Yes, Judge. Thank you. I've been able to review the discovery, and I believe for the most part, Mr. Parsons has also been able to review the discovery. We've talked a lot about a lot of issues, and we've also talked about, if I may, my sense that we needed to address issues of an evidentiary nature, thus the 6 motions that I filed on Wednesday evening. I've discussed all of those motions with Mr. Parsons. After hours, Mr. Parsons left a number of voicemails at my office addressing not so much concerns, but some house cleaning matters, if you will, in terms of what he'd like to see me amend in those pretrial motions. So one of the things I'd like to address today, and I've told Mr. Sharp this before the hearing, I'm going to be asking the court leave, and I'm going to make this an oral motion for leave to file an amended pretrial motion on certain of the motions that have been filed, just to add some things and to clean some things up. And it doesn't really change the sum and substance of any of the motions, just some things that are important to Mr. Parsons that I think he's got a concern about. But Judge, in terms of all of that, I have filed the motions that at this point, in my experience, I deem prudent and reasonable. And I know a number of those motions, particularly the motions in limine, I know that it's just that they came to me, and so I filed them as I was working through the discovery and working through my thought process about the status of this case. And then, of course, as I've talked about with the court and with Mr. Sharp before, on a telephonic conference we had, was the testimony of Stanley Stump Sr., and I've been able to, maybe my motion speaks for itself, so Judge, if you want to cut me off, I don't want to belabor that, but I've made arrangements that Mr. Stump would be available via Skype to offer the court testimony, and I've made those arrangements through Mr. Stump's wife. Her name is Fanny Stump. They've been very accommodating and said they'll make him available. And then in terms of the motion to suppress...
Can I interrupt just
for a second,
Mr.
of course.
The purpose on the Stanley Stump testimony, were you planning on recording it for the purposes of trial, or were you planning on having it live during the trial via video? What were you planning on? Well,
at this point, the only way I have it set up is through Mr. Stump being available on Skype, and I've talked to somebody who could make that happen up there in British Columbia, in that area. I don't know about, I had honestly, I hadn't thought about trial testimony because I was more concerned about whether the court or Mr. Sharp, through any objections, was even going to let me get into the areas that I want to talk about Mr. Stump about.
Here's my proposal. We are now getting the court, this court, in fact, I just got off the phone with our IT people. We can now use Skype for Business in the court environment. I think it would make some sense to go ahead and have it recorded, and that does have recording features on it.
Good.
It would be a free option. It would be something where we can come into the courtroom here. There can be the security that's needed and that kind of thing. We can do the testimony there. My goal wouldn't, I don't even know that I would necessarily have to be there. It would be much more like a deposition kind of thing. But you could record it using our equipment. If you want me here, I can be here too. But I don't know that I would try to rely too much on Skype itself. I mean, the free version that's sitting out there for everybody else, it has an awful lot of holes in it.
Yes.
And it can be pretty quirky. Plus, I'm not sure what your recording options are on that. But we do have that available for you, and it's for free.
Good.
And it strikes me that what you might want to do is go ahead and get it recorded and then present it to Judge Gerard as to whether he thinks that it is relevant to any of the issues in the case. And at that point in time, then we can make it, if he says it is, then we can take up the issue of how do we do it for the trial. If he says it isn't, we're not really worrying about that anymore.
I understand. I think Mr. Stump, on his end, though, maybe I'm not familiar enough with the process in court here, but he's going to be on Skype on that end.
What we would do is give a secure line.
Yes.
And it's Skype on his end too, but we tell him this is the meeting room you're dialing into.
Oh, I see, yes.
And then it has the recording equipment on it. The problem that you have with regular Skype is, I've used it enough to know I don't think there's an awful lot of recording options in there. And you'd be sitting there with a video camera trying to videotape what's showing up on a screen, as opposed to just hitting a button in our system that records it as it goes. In other words, it wouldn't work differently for him, except that he would have to be in a high Wi-Fi area, but he's going to have to be in a high Wi-Fi area no matter which option he goes. I'm giving you the option to use our system because, number one, it's secure, number two, it records.
I think that's I like that idea. I think it's very prudent, and that's the procedure that I would like to see. Okay.
Any problem with that, Mr.?
Obviously, I'm not conceding the admissibility of any of this, but in terms of a process of I guess, securing his testimony, I don't have a problem with it.
I think that we should at least secure the testimony using that method, and then give Judge Gerard the opportunity to decide whether it's admissible or not. And at that point in time, if Judge Gerard says that it is admissible and relevant, or if the government even at that point in time says, now that I've heard what he has to say, I think it's admissible and relevant, then we'll take up the next issue of how do we get it ready for a courtroom. And it may be that you just use what you've already recorded, and it may be that you want to do something different, but we don't have to address that today.
Yes. Very good.
Okay?
Good.
So that takes care of 107 automatically, I think.
Great.
All right.
And the other ones I had, Judge, that I hadn't mentioned, well, we hadn't talked about the motion to suppress, really, but the other two I had were simply 404B materials that I've requested from Mr. Sharp pursuant to motion, and then, of course, prior testimony, including any prior grand jury testimony as it relates to Mr. Parsons.
All right.
But I don't know if we want to take those up today or when we get a hearing date on the motion to suppress.
On the 404B, that usually comes up a little bit closer to, we don't even have a trial date at this point in time, so it usually comes up down the path, so does the motions in limine. And the motion to produce the sworn testimony, what's the government's position on that?
Pull out which one that is, Judge.
It should be labeled at the top as 105.
I don't have any objection to that.
All right. So 105 is resolved, 107 is resolved, 106 on the 404B evidence. What is the government's position on that?
I don't think I have an objection to that, but I want to give some thought to it. I'm going to be filing a brief, and I can tell the court that on several of these motions, I'm either going to be conceding them in whole or in part.
Sure.
But I'd like to have a couple days to
Sure.
think about the 404B part of it.
Yeah, usually, like I said, usually there's a briefing process on that. All right, that brings us to the motion to suppress, and it's a motion to suppress, as I'm understanding it, challenges the affidavit and challenges the probable cause to support the search warrant. Is that correct?
Yes, Judge, and I did file an accompanying brief.
I did see that.
Okay, good.
What I would ask that you do, Mr. Shensi, is could you go ahead and file the index, or unless you have those here, we could go ahead and do it as marking the documents, and what I mean is the affidavit, or the application, the warrant, and the warrant return.
I think I
have those?
Well, I have photocopies that I'd simply produced off of Mr. Sharp's.
Do you remember what
drive.
the case number, what the MJ case number was on that? Then I can find it in our system. And I'll just take judicial notice of it,
I
and
might
then we're
have
done.
it, Judge, just a second.
Okay. Finding a search warrant in our MJ system is not easy. We really have to.
Maybe I can.
I think I may have it right here. If I can open this. It's downloading. I've got a little bit more to go.
Might it be 417 MJ 3059?
Okay.
Does that sound?
Let me see if that looks right. And I can't recall, was there more than one?
There was 2 warrants. The other one was of a computer that has no impact at all on this case.
Oh, okay.
This is the one of the Piper Cherokee.
Okay, so.
I believe there was actually a third warrant, actually, on one of the government's witnesses' home. Reverka?
Yeah, that's right. And that's related to the
Right.
computer thing. You're right.
So 3 total.
So I'm going to make sure that we're using the right one here. Because then what I will do is just have Tawana put it in the.
Judge, I show 4:17 MJ 3029.
Oh, maybe I read. Sorry.
Okay, hang on. Let me see what, I have the search warrant here, so hang on. Under 3059, what we're searching is a residence and the real estate.
Yeah.
Okay, is that the right one or the wrong one? Okay, so 3029, I should try? Okay, hang on. Of course they have only one digit apart. It doesn't make it at all confusing.
I've opened up the document. It is 3029.
Yes, okay. So is it 3029?
Yes,
Okay.
I accept that.
All right, so I will take judicial notice of the documents that are filed of record, and for the record, that would include the search warrant issued along with the search warrant application and the warrant return. So in 17 MJ 3029.
Your Honor, would the court consider unsealing that so that it makes it easier for me to file a brief describing the contents of it? And
Sure, I can do that. I can either do that, or what I could do is just go ahead and have these documents filed in this case. I think that might be easier.
yeah.
Okay, I'll do that. We'll have them filed in this case as being the information that the court considered on the motion to suppress. Now, is there going to be any further evidence in support of the motion to suppress?
Judge, I believe there needs to be, and I say that because in the body of my motion and in the brief, from my review of the discovery, and there may be a Franks issue. I don't know, but there may be, so I wanted to at least bring it up at this point. As indicated, from what I can see in the discovery, it appears that the sheriff of Furnace County applied for and possibly received a warrant earlier, much earlier, to search that airplane. I see that there's a search warrant from Furnace County. There's no affidavit, but there's a search warrant. I don't see that it's signed, but certainly that indicates to me that an affidavit was very possibly provided to a local county court judge in Furnace County.
How does that create an issue for Franks? And
Well,
let me make sure you know, I'm not going to give you a hearing absent that threshold showing.
No, I understand, and I even mentioned in the brief that I understand it's a high bar. I do. And then the other part of it, Judge, was I thought there had been an inventory search of the vehicle, of the airplane, prior to, because there's some mention in the affidavit that the airplane has essentially been sitting undisturbed, and that's the impression that I got from reading the affidavit. I don't think that's correct. I think it had been pulled on the tarmac at least twice. I believe that there was an inventory search done of it. Again, the sheriff of Furnace County makes mention of that in one of the pieces of discovery, that there was an inventory. How extensive of an inventory search did the sheriff of Furnace County do on that airplane on that given date? I don't know. But given that there may have been 2 prior searches of the airplane that wasn't mentioned in the affidavit in support of the application for the search warrant, it just seems to me that's something that Mr. Parsons has a right to explore.
Okay, and so you understand what I would be looking at. If you're going to submit that, I'm going to be looking at whether that information would have changed the analysis of probable cause.
Right.
And absent finding any, let's say it exists, absent finding any indication that it was relevant material or would have changed the analysis, you won't be getting a hearing. But how long do you need to get that stuff to me?
Well,
because it sounds like you need to amend motions too, so it strikes me that we set one date to get all of that done.
I think that's good. Yes, I do. And it's going to take, it may take a while. I plan on going through the online. I can get to a case in Furnace County through www.nebraska.gov/subscriber. I don't know if anybody in this courtroom uses that except me, because that's on the state level. But I think I can gain access to if and when an application was requested and what happened in that regard. All I know, Judge, is that during the course of looking at 500 pages of discovery, I saw in there that a search warrant was given to the sheriff to search the airplane. And that's all I saw. But it raised, at least on Mr. Parsons' behalf, because he and I talked about it, so I felt compelled to address it, as did he. At least it indicated that maybe a search had been done previously of that, and it just also seemed to me at that point that if one had been done or an inventory search had been done when the plane was first put into storage, that maybe that should have been told to the court.
Okay.
That's all.
So, if I give you 3 weeks to amend, 2 weeks?
Oh, I think 2 weeks is more than enough.
2 weeks or 3 weeks, or what did you say?
2 weeks is more than enough.
2 weeks? Okay. 2 weeks to amend and to provide to the court any additional information to meet the threshold showing.
Yes, Judge.
Any objection to that from the government side?
No, Your Honor, I would request to have 5 days after that date to file a responsive brief.
I think that's, are you sure you only want 5 days? 5 days is not an awful lot of time. Okay.
I can do it.
All right.
Well, actually, when's that going to end?
Okay, that's a good question. We've got holidays coming up. The reason I said it, are you sure that's all you want, is it is the summer and people do have.
And I'll tell the court, this is my own personal problem, but I'm moving my daughter to California, and I'm leaving on June 7th, returning on, I'll be back to work on the 18th. So.
Okay. Yeah, you don't want only 5 days, because Mr. Shensi's deadline will be the 8th of June. And then if I went 5 days after that, it would be during the time frame that you're gone. So how about if we go to the 25th?
Okay, that's fine.
And absent, so what I'm going to do is I'm going to take judicial notice of the documents in 17 MJ 3029. I'll pull them down and put them on the docket in this case as the index to go along with the motion to suppress. I'll set a deadline for Mr. Shensi to, on behalf of the defendant, submit any additional evidence in support of the motion to suppress by June 8th. The government's response needs to be filed by June 25th. And then any amendments to, are there any of the other motions in here that you need to amend, Mr. Shensi?
Yes, Judge. And it is contained in filing docket number 110.
Okay.
Paragraph 2. I'd like to reword that extensively. I would tell the court that Mr. Parsons brought to my attention his thoughts, without going into them, his thoughts about how I worded paragraph 2. And frankly, I think Mr. Parsons has a good point in his comments to me about paragraph 2. It's not going to change the sum and substance of the matter itself. I will tell the court that. I just want to clean it up a little bit and put some additional language in there, that's all.
Okay. Do you need to amend 109? That is another motion in limine.
No, Judge.
Okay. So, we're going to grant number 105, which on the government's conceding 105, which is the producing the prior sworn testimony. We're going to grant 107, which is the motion to produce and allow testimony of Stanley Stump Sr. and Mr. Shensi, and you may wish to contact our IT department for assistance with that, so just use that.
Yes,
or
Judge.
you can contact my chambers too, and I can help you out with that if you want.
That'd be great.
Okay.
Where would you prefer that we conduct this examination of Mr. Stump?
If there's a chance that your client is going to want to use it at trial, he needs to be present
Yes.
during the testimony, so it
And I would want him to be.
strikes me that it should happen here in the courthouse.
Good. I had also advised Mrs. Stump that her husband would need to be sworn in, subject to not only direct but also cross, and possibly any questions by the court. Do you deem that appropriate, that I told him that?
Oh, that's fine.
Okay.
Does the government have any problem with them being sworn in by me on this end?
No.
Okay, so they don't need to find somebody there to swear them in and sit next to them.
Good.
I can do that over.
They just had many questions procedurally, how
Yeah.
we were going to do this.
Yeah, and procedurally, I mean, on a technical basis, when you swear somebody in, they're supposed to be sitting right next to you. But those rules were made during a time when we didn't have all of these things where you can see each other and things like that.
Well, they
So
even
that's
thought
why
they
I
might-
covered that with Mr. Sharp. So,
Yes, they thought they might have to go to the local courthouse and maybe do it there, and I told them no, that was not going to be
No.
necessary.
so long as they have what they're going to need on their end, they're going to need to have strong Wi-Fi, and they're going to need to have a computer with a camera. And or they can use a iPad.
Yes.
But every laptop has a camera nowadays. Every iPad has a camera on it. So it's not hard to get accomplished anymore.
Good.
Okay?
Well, they must have an IT guy up there because his name's Jonathan, I would tell you, and apparently he's equipped he's equipped to do this. So I've been told.
Okay, that'll work then. And then what we'll do is we'll just schedule it to be in the courtroom, and either I will be present and just swear him in, and that way, if you choose to use, if Judge Gerard decides that it is relevant and you choose to use that recording for the trial itself, then the defendant will have been present during the testimony. Okay?
Yes, Judge.
Okay.
Can I
I
address
believe
one?
your client wants to talk to you.
Oh, I'm sorry. Can we have just a moment, Judge?
Yeah.
Is there any way to ask if she can request that the U.S. Marshal remove me from max security? If I'm at a lower level security, I can get access to the library 5 days a week because they could move me to a pod where I've got greater access right now. I'm on a very restricted pod. That's why my access is limited.
Right.
And it prevents
We're
me
going to address today about your access to the law library. We are.
That's why I'm so limited in,
No, I know.
you know.
Do you want me to still bring up with the court about having Sue Holland possibly testify?
Yeah, because she has,
I know what she's got, but do you want me to address that today?
if you like, certainly.
Well, you asked me that she might get Sue Holland, but bring it up today, I will.
Well, I understand that, but that would be up to her to decide if she's willing to testify. If
All
we
right.
clarify it now, then it's approved on it.
Okay. Judge, could I address one other thing, please?
Sure.
This sort of goes along with any testimony by Mr. Stump. And it's in regards to an individual named Sue Holland. And I think the court is aware of that name and the position she holds within the...
I am.
There's been some discussion about possibly asking the court that she testify and offer the court testimony about, I would proffer to the court at this point without getting into the specifics or the facts, about the nature of her position and about the indictments and the arrest warrants that she had issued. I see difficulties with that. I see potential pitfalls if she's placed under oath, subject to cross-examination. I think that's a very precarious path we may go down. I'm not really inclined to go down that path, but on behalf of Mr. Parsons, I wanted to advise the court that I may be, and I want to emphasize the words may, be filing a similar motions as it relates to her, premised upon the same analysis that I've used for Mr. Stump.
She's currently facing criminal charges? Is she currently facing criminal?
I'm told that up in Canada she's got charges that she's at least been interviewed on and possibly charged on.
Okay.
Okay,
go ahead.
Oh, I'm sorry. I'm glad you brought that up, Judge. Fanny Stump mentioned to me that she, in fact, Ms. Holland, was in fact on trial up there, but apparently either something got worked out or she was successful, but apparently she's free now and she's at home, and I've actually tried to, through this IT fellow up there, tried to get a hold of her, and I'm going to continue to do so, but I'm at a loss to tell the court I know exactly what happened to her up there because I really don't know, but I'll find out.
And the only reason I asked the question is just to make sure it perked my interest. If she is facing criminal charges, we need to be coordinating with her attorney too.
Yes, Judge.
So, okay, I'm looking at for trial dates now. So, because the way we've got this laid out, I'm fairly confident that I can get the matters that, the pretrial matters, including the motions to suppress and such, out fairly quickly. So I'm looking in August as far as having a trial date. What's the party's position on that?
Your Honor, I'm out the week of August 20th. The rest of the month I can make work.
Okay. How about the week of August 14th? Are you open?
Yes.
All right, Mr. Shensi?
Judge, I'm scheduled for a trial in Douglas County District Court that's supposed to go the 15th through the 17th, but I would also tell the court I think that case is going to settle. So
Okay.
I'm happy to set it in at that point.
All right. Tawana, could you do me a favor and look at Judge Gerard's CEO calendar and make sure that I'm not messing him
Judge,
up?
I'm sorry. Could I... the 16th could be problematic for me, too. Might we be able to look at... Mr. Sharp, did you say you were not available the week of
The week of the
August
20th. The week after that would be fine. The week before the 14th would be fine. Just that 1 week.
The week of the August 6th is fine with me also, and the week of August 27th is also fine with me, if that would work for the court.
How's August 6th work?
It works.
Good.
And Tawana, what's August 6th look like? I'm sure he's got other trials there, but I'm not going to worry about that. But he is in for trial. Yes. Okay. We're going to set the trial for August 6th.
The issue with Sue is that she can say,
No, wait. I know what she's going to say. I know.
All right. Anything else that we can take up at this point?
Yes, Your Honor.
Okay.
I don't know that this requires any intervention by the court. In fact, I don't think it does, but I want to put it on the record because I think it may be an issue at some point. I received some email contact from, it was both from the marshals and from Douglas County Corrections. What I'm being told is that since Mr. Parsons is now represented by counsel, that is likely to result in his library time at Douglas County Corrections being cut down to 1 hour per week from his current 3 hours per week. That's just the standard rule they have for all inmates, represented or not. And it makes a difference in terms of where the discovery is maintained. Again, I don't know that that's the court's business, but I think we're going to end up having to talk about that at some point, so I thought this was a good chance to do it.
All right. Mr. Shensi.
I can assure the court, and I'm sure the court already knows this, as does Mr. Sharp, Mr. Parson desires more time in the law library, not less, so this could be problematic.
Okay. And Mr. Sharp is correct. I'm not in the... I can't force or enter orders requiring more or less library time. I can say that to Mr. Parsons that you have an excellent attorney, and he is your attorney. And as such, he is the one who is responsible for finding the law and talking to you about how the law applies to your case, talking you through the discovery. And I certainly understand Douglas County Corrections. They have a lot of people in that facility, and they cannot have a situation where not everybody gets access to the law library who wants it. That's the only thing I will say on the topic, because I don't have the authority to enter a ruling one way or another on any of that. So, all right. Anything else?
can I respond regarding the access? Because there's virtually nobody ever in there.
But the judge can't.
Anything else, Mr. Shensi?
No, I would just tell the court that Mr. Sharp and I talked about this. I've had contact with Michael Rupiper. He's over at the Douglas County Correctional Center, and I've known him for a number of years. He also runs house arrest, work release, etc. But he's indicated to me that I don't want to speak for him. Maybe I shouldn't even say what I'm going to say, but I'll say it anyway. They may make an exception to allow Mr. Parsons to have access. I hope that happens, because Mr. Parsons would spend the entire days in the law library if given the opportunity. So 1 hour a week is going to be... But again, we understand this isn't the court's decision.
The other way that I've seen this done, and it recently in a Lincoln case that had some of the same issues being brought up, was that the compromise was that the defendant advised the attorney of the issue they wanted the research on, and the attorney sent the copies to the defendant at the jail.
Yes,
so,
Judge.
I mean, there are ways around it, but those ways cannot get to the point that Douglas County Corrections faces domination of the library by a single defendant. All defendants are to be treated equal. We are in recess.
Thank you, Judge.